In this recording, we'll consider the two categories of exceptions to the inadmissibility of hearsay evidence provided for in the Queensland Evidence Act, namely those exceptions to do with books of account and those related to particular sorts of statements and representations. Remember that we said in the previous recording that in trials which take place in Queensland courts, exceptions to the inadmissibility of oral hearsay evidence are generally to be found in the common law, and exceptions to the inadmissibility of documentary hearsay evidence are generally going to be found in legislation. So the exceptions we're looking at here apply to what we'll see broadly defined as documentary evidence in the Evidence Act. You need to recall as we go through this material the definitions of both document and statement, which are found in the dictionary Schedule 3 of the Queensland Evidence Act. I've got them there on the screen for you. The first of the two major categories we're going to consider are those which are related to the so-called books of account, and they're provided for in Part 5, Division 6 of the Act. The provisions in sections 83 to 91 allow basically for the common sense rule that where you have books and other documents in which you keep the records of a business, then the entries in those books are original evidence of the matter they record. So that might be financial records listing the money that's coming in and going out of the business, assets, registers, which list what property and stock the business owns. And those recorded statements would of course be hearsay, since they're representations of any fact which are made by a person or a computer or some other electronic device, and we'd be tendering them as evidence of the truth or the accuracy of those accounts or records. Any of those things could also be led, of course, as a piece of real evidence, but if we're interested in the accuracy of the data contained in them, then we're relying on them for a hearsay purpose. So if we're tendering, let's say, a logbook or a cash book from a business, and all we want to do is establish that one was kept, then we're not interested in the statements inside it and whether they're true and accurate. We could just leave it as a piece of real evidence. If we're interested in the truth of the statements contained in these documents, all right, the truth of what they expressly or impliedly assert, then we're leading them for a hearsay purpose. We're leading them as documents, and therefore we're going to need to find an exception to the inadmissibility of inherently unreliable hearsay evidence, and so we'll be looking for an exception in the Evidence Act. Two important other definitions to keep in mind for the purposes of this topic are that of an undertaking and of a book of account. An undertaking is really just some sort of business or a public sector agency or some profession or trade or occupation. It's defined in Schedule 3 as including any public administration, which really just means a government department or some sort of entity that's controlled by government, and any business or profession, occupation, calling, trade, etc., whether it's public or private. A book of account includes any document used in the ordinary course of one of those undertakings, all right? So if it's one of these things defined as an undertaking, then a book of account is a document that's used in the ordinary course of what one of these things does to record the financial transactions of the undertaking, or to record anything that it's required or otherwise dealt with by, so that could be the assets register that I was talking about, anything that's produced in or held for or on behalf of or taken or lost from the undertaking, and any particulars which are relating to those things. So it's a very broad idea, this idea of a book of account. It's a lot more than just, some sort of financial record. It's basically all of the records that are kept by that undertaking or that business or that organisation in the course of doing what it does. So a book of account and an undertaking could be one used in an actual business, in a particular business, or one that's typically used by some sort of profession or trade or occupation. These are the most relevant provisions to be aware of, and they're the ones you usually apply when you're looking at whether a particular statement in a book of account is going to be admitted. The operative provision in the book of account exception is section 84. Remember that the underlying assumption with all the exceptions we're looking at in this recording is that we have documentary evidence that we want to tender as if it was oral testimony. In other words, we want the documents to speak the information they contain to the court as evidence of the truth of what it is the information in them is asserting. That's what all of these exceptions are about. They're about a document speaking something to the court as an alternative to the person who made the statement or made the record coming to do it. So this section 84, entries in books of account to be evidence, will apply to both civil and criminal proceedings. What is a book of account? Apart from the broad definition that we've already got, in that case of Swindells and Hosking, there was a good example considered by the Queensland District Court. That involved the question of whether the notes taken by a general practitioner during his consultation with a patient would be a book of account. At first blush, it doesn't seem like it, does it? So, the sort of handwritten things that no one can ever read anyway, handwritten notes that the doctor takes when you go to see them and they're writing about your symptoms and your history, etc. Not the things that are necessarily typed up on a computer, but the handwritten notes. Question is, do they form the books of account of the undertaking, in that case, the medical practice? Well, the court said they were. They formed part of the medical practice's records. So a book of account, remember, is any document used in the ordinary course of the undertaking to record anything acquired or otherwise dealt with by it and any other particulars relating to such a thing. So it's not just the official log or the diary or any other formal typed up records that are made at the end of the day, so the raw notes and records and observations that are made also form part of the books of account. At some stage, go back up to those four provisions and have a look at how you think you'd apply them to see how the medical notes, the doctor's notes, would have been admitted in the Swindells case. So, for example, have a look up here at 64. Entries in a book of accounts. So we're talking about notes in the doctor's, day book or notebook. Copy of an entry in a book of account shall be evidence of the entry and of the matters, transactions and accounts recorded. A copy of an entry in a book of accounts. So it might just be, a verified photocopy of the relevant page in the doctor's handbook or notebook. All right, that will be considered to be evidence. What about proof that it really is a book of account? Well, section 85 is telling us that the entry in the book or a copy of it won't be admissible in evidence unless it's first proved that the book was at the time of the making of the entry one of the ordinary books of account of the undertaking which it purports to relate was made in the usual and ordinary course of that undertaking. So how do you do that? You've got to prove, first of all, that this document really is part of the ordinary book of account that's used in the undertaking. And it's telling us in 85.2 that you can prove that by just getting a responsible person who's familiar with the books of account that are used in that undertaking, and they can do that orally or by an affidavit, or just by a declaration made before a JP or a Commissioner for Declarations. All right, so it's just a matter of getting a copy of perhaps a photocopy of the relevant entry in the book. In this case, it would be the doctor's notebook, getting a JP or a Commissioner for Declarations to sign it as a verified copy when it's presented by a person from the undertaking. So it could be the doctor themselves, or it could be one of the administrative staff working in the clinic. Right, and then it's potentially admissible because it's now been proved that it is a book of account. If it's a copy, in this case, let's say we are talking about a copy, we need further proof that the copy has been examined with the original entry and is correct. How do you do that? Right, so this is if you're definitely going with a copy and not just getting a responsible person to, in the chain of evidence to deliver it to the court. All right, so in this case, it could simply be a person filling out an affidavit from the clinic saying, yeah, this is a copy of or this is the book itself. If it's a photocopy, you could get someone who's examined the copy with the original, and it can either be tendered orally or by affidavit. So you could get someone who works at the clinic, let's say one of the administrative staff, to say, I've had a look at the doctor can't come in today, and that's a requirement of all of these exceptions. You'll see that for some reason, there's a good reason why the doctor himself or the person who made the document of the statement isn't in the court. In this case, it was probably the doctor who, had a lot of patients and needed to be in the clinic or in surgery or something that day. An administrative person from the practice of the clinic comes in and says, I've checked the original of the doctor's notebook of the notes with this copy, and I'm here to declare to the court that this is a true and accurate copy. And that person could be a witness who's called just to say, yes, this is the book. And then that witness is just verifying the copy. They're not verifying the accuracy of the contents. It's the book of account that does that. Or it could just be given to, as we said before, to a JP or a Commissioner for Declarations to get a verified copy, as long as then that same process would need to be followed. And 87, a person engaged in any undertaking or an employee, so in this case, let's say the administrative person working for the clinic, can't be compelled to produce any book of accounts. So let's say in this case it's the GP isn't a party to the proceeding, but one of the parties, let's say in a personal injury matter, let's say the defendant wants to get a copy of those notes to check on what the patient's health was like, and for some reason it's not subject to any particular privilege, then they can't just be the doctor. Neither the doctor nor the administrative officer from the clinic can be compelled to produce that account, all right, to the book of account or the notes, or to appear as a witness, unless by order of a court. So it would require probably, you'd have to subpoena them, you'd have to seek a subpoena to get them to come into court. You can't just compel them. So that's section 84. Remember that section 85 provides that, as I just said, proof that the document really is a book of account will be required in order for it to be admitted. So it has to have been a book at the time the entry made and was made in the usual course of the business. All right. So apart from just being the sort of document or record that's kept in that business, it had to have been that undertaking. It had to have had that quality at the time when it was made. The rules, the second category now of documentary exceptions, the rules in sections 92 to 103, which you can see set out for you here, extend the purposes for which documentary evidence can be made admissible, catering for some situations of necessity, and for where it's just absolutely necessary, there's no other alternative but to have the evidence in documentary form, and for some relatively modern forms of statements like those which are generated by computers and analytical software such as those which produce DNA certificates, etc. All right, so some things which are information which is not directly produced by a person. I've set out for you there on the screen a copy of the relevant provisions and what each of them refer to, so you can look through each of those now. Take the time to look through them. You don't need to read the whole sections. We'll talk about most of them, but at least have them ready to make a summary in your notes. There's a provision for the admissibility of documentary evidence in civil matters and admissibility of documentary evidence in criminal cases, all right? Separate provisions this time, unlike Section 84, which applied to both civil and criminal matters. There's provision for an exception to hearsay where a statement can be admissible when it's been made by a child or a person with impairment of mind. All right, so a child or a person with impairment of mind, and for that reason, it's not reasonable to expect them to come into the court and give their evidence orally. Evidence of a representation in some prescribed criminal proceedings if the person who made the statement, the representation, isn't now available. And that'll only be a prescribed criminal proceeding means a trial in relation to an offence that's created in chapters 28 to 32 of the Criminal Code. All right, so it has to be something in relation to that. So it's evidence of something that a person said, and the person who made that for some reason is now not available to come to the trial. Admissibility of evidence concerning credibility of people responsible for a statement. We'll talk about that a little bit later. It's just a fairness provision, which means if you're faced with evidence of that sort, you've got a right to respond to the credibility of the witness, even though, because they're not in court obviously now to give the evidence. All right, so you can still attack their credibility. This is the provision for the sort of statements which are produced by computers using particular sort of software. We call them devices and processors now. Admissibility of DNA evidentiary certificates, etc. And I've just done screen capture there with some useful reminders to you about some of the provisions in Part 6, the second category. The exception which is provided for in Section 92 of the Act applies only to matters in the civil jurisdiction, not criminal. Get yourself a copy of Section 92 now to put in your notes and we'll have a look at it. This situation arises where we want or we need to use statements in some document as testimony. So what we're looking at is at a trial or some other court proceeding where direct oral evidence of a fact would be admissible, if we could get someone to come and give it to the court, meaning that you need to be able to point to some real person who could theoretically have been called to give oral evidence of the fact or the facts which are contained in the document that you want tendered, that you've got a hold of. All right, so you have to go through the process of saying, I want to call this witness. They're not available. This is why we need to get the document in. Now, if we had a person in the witness box giving evidence, remember, they can't just blurt out anything and have that taken into evidence. They aren't able to give opinion evidence, that we'll talk about in week 12. They can't give inadmissible character evidence or hearsay evidence. So any evidence of that sort of nature would be subject to some exclusionary rule if a person was giving their evidence live as oral testimony. So it's still going to be excluded from the contents of a document which you tender with the same material in it. It doesn't exclude any of that material, any of that sort of exclude those exclusionary doctrines that relate to the material which is actually in the document or the statement itself, separately from whether you can have it tendered just because it's hearsay itself. It's a document rather than the person who made the statement being there to give it. So the upshot is that if we do have a proceeding where witnesses could appear and in which they are permitted to give oral evidence of a certain fact, then any statement which is contained in a document which tends to establish that same fact is potentially admissible by operation of Section 92. Section 92 provides us then with two alternative bases of admissibility for a hearsay statement contained in a document. First, where the maker of that statement, which is contained in the document, had personal knowledge and is called to give evidence. What that means is that we're theoretically putting the person who made the statement in the witness box, but we're tendering their Section 92 statement as their evidence in chief. So they're giving evidence via this document. That wouldn't normally, of course, be permitted because it's in breach of the prior consistent statement exclusionary rule, but not if you can satisfy Section 92. And so that first alternative basis gives us scope where we have to be able to call a witness, which is ironic because when you really need this exception to hearsay is when the person who actually made the oral statement out of court isn't available for whatever reason. Of course, there's nothing in 92 to prevent you actually calling a witness, but then just tendering the document as their evidence in chief, in which case they generally just go straight into cross-examination, all right? So you can use it both as an alternative to a witness turning up at all, or you can use it as an alternative to them giving oral evidence as their evidence in chief. And the second alternative basis for admissibility in Section 92 is if the document is a record of an undertaking made from information which is supplied directly or indirectly by a person who had personal knowledge. So when can we use Section 92 to get in a statement from our document as the evidence and avoid having to call a witness and open them up to cross-examination? Well, for either of those bases to be available, you need to satisfy the court that the person isn't actually available to give evidence for some good reason. Either they're dead, they're mentally or physically unable to attend, they're out of the jurisdiction and it's either impossible to contact them or to locate them, or it's unrealistic to get them back. And notice how that's provided for by reading through all of subsection 2. In fact, I'd do that now and be aware of those conditions. I've extracted them there, A to F, on the screen there for you. So you need to be able to satisfy one of those. So what you do is you call the witness, you say, I want to call this witness to give evidence. If they were here, the evidence they would give to the court would be admissible. Despite the fact that I've called them, they cannot appear for one of these reasons. And if the court agrees, then provided one of these bases is satisfied, they can then have that evidence tendered in documentary form. Let's go back to that for a minute. There are clearly some threshold elements of that exception, of those two exceptions provided for in 92, and you need to specify them if you're doing this in an assessment or in court. All right, so how each of those elements are met before you can conclude that a piece of hearsay in a document can nevertheless be admitted because of the 92 exception. So remember, first of all, you need to satisfy the court that what's presented is a statement. That's pretty basic. It's defined in Schedule 3 as including any representation of fact, whether made in words or otherwise, whether made by a person, computer or otherwise, and it has to be a statement of fact. All right, that can include admissible opinion. All right, so it could be expert opinion, and in fact, what happens in many cases is that expert opinion will be tendered to the court, especially in civil proceedings, by the evidence in chief will be tendered in documentary form rather than the expert coming in there and spending, sometimes hours going through all the detail. They will simply provide that in affidavit form as a statement. Each side will do that if they've got conflicting experts, and if necessary, they will then simply turn up to be cross-examined. Another threshold is that it has to be contained, this statement of fact has to be contained in a document, and we know there's that wide definition of document in Schedule 3. It has to be a statement which tends to establish a fact. All right, so it just means it has to have the quality of circumstantial or direct evidence, and it has to be a statement for which direct oral evidence would be admissible. So the person's called as a witness, but they can't attend, and the reason for for non-attendance is one of those reasons that's set down in subsection 2A to F. Then moving on to section 93, we use that now if we're talking about criminal proceedings. It's actually got a narrower ambit than the section 92 exception. It still has that overriding threshold element, that is, direct oral evidence of a fact must have been capable of being given by a person. We could have called that person into the witness box and heard their evidence of this fact given under oath, with the usual exclusionary rules applied if necessary, and with the forensic filter of cross-examination deployed to test the evidence, all right, if they were available. Remember, when we looked at definitions of hearsay last time, the House of Lords in Meyer wanted to exclude the inherently reliable exception. Those very reliable microfilm records, remember, in the car stealing and rebadging operation. On the microfilm, there were records of engine block numbers taken down at the production line. There was no reason whatsoever to doubt their authenticity. And with these documentary evidence, that's why they're usually admitted. A doctor's notes. Why would a doctor generally lie or make inaccurate notes about a patient's health in anticipation that years later or months later they might be involved in litigation? It was the same with this. Why would there be any need to falsify the information on the engine block records? So no reason to doubt their authenticity, but as a matter of law, they were classic examples of hearsay. All right, a statement made out of court by a person who's not being called. They weren't calling the person from the production line who'd copied the numbers down. They might not have even known who he was, and they were leading that as evidence of the truth of what they asserted, namely that the numbers on the engines to which the plates on the stolen cars were attached were different to the ones from the factory, and therefore evidence that they were different engines. I mean, that's obviously hearsay, obviously inadmissible, prima facie. But after that case, the UK Parliament legislated as a direct result of Meyer, because they said, it's ridiculous, to create an exception so that that sort of evidence could be admitted. And in Queensland, we did the same thing with Section 93 of the Evidence Act, because it would be ridiculous, wouldn't it, if that continued to happen, that someone who was obviously guilty of stealing and rebadging cars was able to avoid criminal responsibility because of the operation of the hearsay rule, which is supposed to protect the integrity of evidence. So put a copy of Section 93 in your notes, read the relevant subsections as we examine them. So for the purposes of Section 93 now, we have a statement in a document, and we wanted an evidence because it's relevant to a fact in issue. If the document's related to any trade or business now, all right, not an undertaking, a trade or business, and if there's a person who has personal knowledge about the contents of the document, who could, if they were available, come and give oral testimony about that fact, then if we can satisfy the court that they can't come to give that oral evidence, we might be able to tender just the statement itself in the document. If the witness could have also given opinion evidence about a fact in issue, all right, so expert opinion, and that opinion's in the document, that can also ground the exception. But we'll talk about that, the difference between lay and opinion evidence in week 12. All right. And these are the reasons which will satisfy the court as the person not being available to give evidence. So a little bit more stringent than the civil equivalent in 92. Remember, we said this is narrower. So it doesn't apply to an undertaking, only to a business, and the reasons for non-availability of the witness are more strict. Section 93A, the exception for a child, the evidence of a child or an intellectually impaired person. I've got a reasonably detailed summary of that exception on the slide. Just read through my analysis and have a copy of Section 93A in your notes. This usually applies to statements that are recorded electronically in relation to sexual assault cases, right? So the document will be a video recording of an interview or a statement, and often with a child in relation to sexual assault. They don't want to put them through cross-examination, the trauma of that. It would still, of course, be subject to the discretion which a judge always has, pursuant to Section 130 of the Act, to reject evidence in a criminal proceeding on the grounds of unfairness to the person charged. All right, you need to know that provision if you haven't looked at it already. There's always a discretion of a court, of a judge there, and that's not inconsistent with the common law rules we've looked at before. You know, the fairness discretion which applies to all matters, not just criminal, to not admit evidence which is otherwise admissible. All right, not a discretion to admit evidence which is not admissible. Judge can never do that. Section 95. This is what used to be called evidence from computer records. Now it's referred to as the admissibility of statements in documents or things which are produced by processors or devices. So 95 sub 1 tells us a statement which is contained in a document produced by a process or a device is going to be admissible if it meets the conditions in the provision, despite the fact that it's hearsay. So this is, we're not talking here about some document that's just typed up on their computer, all right? It's not that sort of document that you'd use the other documentary exceptions for. And it would apply, this exception applies in civil and criminal proceedings. So we have all of this sort of software now and these digital devices which allow us to measure and take readings of things, and scarily, to record metadata, URLs people may have surfed to, their search terms, who they called, when they called them, and for how long. All of that stuff's likely now to be admissible under Section 95 when the software or the algorithm or whatever makes the record. Also, think about the digital trails and signatures left by all of us, I guess, as we move around these days, that are recorded by not just mobile phone towers, but any sort of Bluetooth or Wi-Fi signal. All of that's captured. All is potentially admissible, even though it's hearsay as documentary evidence pursuant to Section 95, and usable in criminal prosecutions as well as in civil proceedings. That sort of data tends to be stored and accessible in a far, far more liberal way than many of the lay population would think. So the amount of data, the amount of a number and detail of statements in documents or things which is produced and stored by processors or devices which is potentially available as evidence in court, absolutely staggering these days. It's not until you get involved in litigation that you realise how much there is. It used to be things like, I can remember in the olden days when you were doing personal injuries cases, or defending someone in a dangerous driving matter, you'd want to subpoena, let's say, the Brisbane City Council for the data which is stored, the algorithm for when traffic lights at a particular intersection change. What's the process? How long do they stay red on one side of the intersection and turn green on the other? We have far more data and richer data and nuance, CCTV and sound recordings, all sorts of things. Anyway, the evidence can be tendered subject to 4 conditions, I think we can identify, and they are in subsection 1. Has to be direct oral evidence of the fact, would need to be admissible first, as is always the case with these things. There has to be an identifiable statement in the document. That statement must have been produced either wholly or partly by a device or a process for the purpose of this provision, and the statement that it produced must tend to establish the fact of which the oral evidence would have been admissible. All right, so it's like direct or circumstantial evidence that affects the probability of some fact in issue being true, that you learned about in weeks 1 and 2. (93B). This is an important one for you to look at. It's not a difficult provision, but it's worth thinking about and understanding the parameters. Where a person with personal knowledge of an asserted fact makes made a representation about that fact, right, about something they knew, during or shortly after the asserted fact that they're made the representation about, and in circumstances making it unlikely to be fabricated, or in circumstances making it highly probable that it's reliable, or against the interests of the makers. All right, so 2 requirements there. It has to be a statement which was made very soon after the asserted fact that it's about, and in circumstances which makes it reliable, and the maker is unavailable to give evidence because they're dead or mentally or physically incapable, the hearsay rule won't apply and the representation is admissible. What's an example? Crown and Crump. In that case, the court had to consider the admissibility of the evidence from Mrs. Carlo. That was the trial of Crump, who was convicted, it was up on the north coast somewhere, of the murder of his de facto wife, Erica Tompkinson. and the Crown had tendered evidence about a statement which Ms. Carlo claimed that Miss Tompkinson had made to her. So it was hearsay, but since Miss Tompkinson was dead, they'd argued that section 93B 2A applied. All right, 93B, here we are, in 93B 2A. So Mrs. Carlo's evidence was just this. She said that the deceased, Miss Tompkinson, had come to see her at her house one morning and told her that she'd stayed away from home up the road at a neighbour's place overnight because her de facto, who was the appellant Crump, had beaten her up. She said that he just went off at her, started thumping into her, and she'd run away. So Miss Carlo didn't say, though, whether when the deceased had come to see her, she'd had any bruises or any other marks on her which were consistent with this story about having been assaulted by Crump the night before. But she did say that she had seen bruising on Mrs. Tompkinson on other occasions. The fact that, according to the deceased, Tompkinson, this conversation that she was having with Miss Carlo was occurring on the morning immediately after she said Crump had assaulted her, made what she said a representation made shortly after the asserted fact happened, all right, within the meaning of subsection 2A, so we've got that. It's going to be a 2A. The difficulty about the admissibility of her evidence, though, was whether the representation was also made in circumstances making it unlikely to have been a fabrication, which is the other necessary element of 2A. Had Ms. Carlo actually observed some bruising or other signs of injury on Miss Tompkinson on that morning, said Justice Davies in his judgment, he would accept that that may have been a circumstance making it unlikely that the representation was a fabrication. But without that additional evidence, he didn't think the condition was met. All right, see, so these are two separate requirements. There was a requirement, the requirement of it being contemporaneous, it had to be close in time, shortly after, that was met, but you couldn't rely on that as also, as it being res geste, making it reliable hearsay. There has to be some other evidence to suggest that it's also inherently reliable, not just that it happens in time. And he said, so, if she'd said in her statement, yeah, she told me immediately afterwards, and there was bruising, then it would have been admissible. But without that additional evidence, he didn't think it was met. It's a neat little example of how it works. And so the Court of Appeal found that her evidence shouldn't have been admitted. You'd be glad to know the fellow was eventually convicted anyway. You can look for yourself at section 93 about warning a jury in relation to admissibility of this sort of evidence. It's not very complicated. Get a copy of that section, put it in your notes. Section 94 just operates, I think I mentioned that before, so that when a party's faced with statements from the other side which have been admitted pursuant to one of these documentary exceptions, so section 84, 92, 93 or 93A, so they're these documentary exceptions where the documents will be tendered, there's no oral evidence given. That party can then still tender some evidence to try and attack the credibility of the person who would have been called to give the oral evidence. All right, so that's just to even up the playing field a little bit. And I think it makes sense. And this 98 discretionary exclusion, it just says that the court retains a discretion to reject any statement or representation, even though the requirements that we've talked about in relation to each of the documentary exceptions, even though they're met, all right? even though they're satisfied if for any reason it appears to be inexpedient in the interests of justice that the statement should be admitted. So there's always a discretion that a judge retains, remember, to not admit evidence even though it is admissible. Right? And there's nothing inconsistent about that. We already know that from the common law. And it applies to all of those statements or representations which are admitted in Part 6. Right. You can see on the final slide there, I've given you screen captures of what the relevant offences are in chapters 28, 29, 28A, chapter 30 and chapter 32 of the code. Because remember, this exception here, all right, where you've got someone who's not available to give their oral evidence and you want it to be admitted in documentary form, that's possible, but only if what was heard, if the representation made by the unavailable witness is in a criminal trial with respect to an offence in chapters 28 to 32. It's a criminal trial, all the other conditions are met, but it's not one of those offences, then the exception in 93B will not apply.